it's an adversarial context. This is not cross-examination. I am not your adversary. I'm here trying to teach you, and I am fallible, and I do make mistakes. But the position of this class in particular, I've not had this in any other class, it's been very different. So much so that several of them out of class emailed me about this. And I do think it's something you need to think about going forward. I tend to be very informal and permissive, but this is not going to fly elsewhere in life. I understand you want to get your notes correct. I also understand that you want to get the information absolutely correct. You should get it right. But the manner in which we respond to a slight error, which was inadvertent and corrected fairly quickly, is really unacceptable. So I'm not going to single anyone else out, but if I see it again, I will ask you to come talk to me personally, because you're here not just to learn about property, but here to learn about life. Law school is about maturity, and something which a lot of people don't have coming to law school. I sure as hell didn't have it. I don't know if I have it now, but it's something we work on throughout our lives. And the lessons you take from this will be far more important if you understand the contours of marital property. It'll be far more important if you get, what a fee simple determinable is. Okay? So I meant to say something earlier, but I kind of let slide because you're a fairly good class, usually well prepared. But the class on Wednesday wasn't the best. So let's try and do better, okay? Comprende? And if you have any questions, you can talk to me after class, whenever you like. Got it? All right, very good. Okay, so we're starting a new topic today. The new topic is leases, all right? And this is probably a topic for this year that is most understandable to a lot of you, because a lot of you have actually signed leases in your lives, right? You've actually had leases, you've approached them, you've signed them, you may have actually read them, although you probably didn't. I usually don't bother reading them because they're too long. But that's actually part of the discipline, okay? One thing to make clear, though, leaseholds are different than fee estates, right? We spent a lot of time on fee simple determinable, life estate, all these other estates, which are fee estates. There's a difference between the fee estates and the leases, okay? And the difference is very important. One is governed by the laws of real property, and one is governed by the laws of leases. These are not the same thing. And there will be very often cases, including the one we do today, where something might blur the lines, where they call something a life estate determinable, or a fee for life, okay? There's often blurry boundaries between the two. But at the outset, I want you to understand what are the key points of leases, okay? And how is it that laws apply differently, okay? All right, well, thank you, Tom. All right. All right, so any questions before we get started? All right. Gettysburg Address, huh? No, all right, so let's get started. There are three main types of leases that I want you to be familiar with. But after we do these three, you're going to see how the lines between them blur and courts start making things up. All right, so to begin, let's keep it simple. Okay? All right. Do you remember where I finished last time? I have no idea. Thanks. All right. Tell me, what is a term of years? What kind of lease estate is that? I don't know. You don't know. It's like the first thing. Did you do the reading?
I did.
Yeah. So what does it mean to have a term of years?
Which means it's going to be on a specific date. It's going to last however many years.
Good. Okay. A term of years, right, is a lease for a fixed period of time, right? You know that it will end no later than a certain date. It could be 1 year, 2 years, 3 years, or between the reading, 500 years or 3,000 years, okay? You know when the lease is signed, it will not extend beyond this date. So if I right now sign a lease that says a lease of 1 year, right? Today's what, November 3rd, 2014. On November 5th, 2014, I'm done, right? There's no opportunity to extend it. There's no opportunity for anything else, right? Slight caveat, terms of lease can end earlier, right? You can have a lease that says, we'll finish on or before November 5th, 2014, right? There's a date certain, but it could actually end before that, okay? The book has these funny stories about these 999-year leases, which are actually kind of ridiculous. There's one they mentioned from Yale University that they own a farm, but they gave a 999-year lease in the 1700s. And what's kind of cool is that the payment has to be made in 28 ounces of silver, right? And every year annually on May 10th, there has to be 28 ounces of silver deposited for payment of the lease. There was another instance with a 999-year lease from Pennsylvania. Okay, Jordan, why do you think anyone would ever bother doing a 999-year lease rather than just giving to someone in fee simple? Because effectively 1,000 years is longer than civilization, right? We don't have any documents that are existing. Magna Carta is what, 800 years old, right? It's longer. That's Magna Carta. Why would anyone bother with a 999-year lease?
I'm not sure in case they wanted to get back.
Well, could they? But let's be very precise. With the term of your lease, when will it end? Exactly right, at 999 years. So there's not really an opportunity to get it back unless what happens?
Unless, the state happens. Or
What would that be in this case? If the lease was for 999 years, what would that be? How do people usually get evicted? What usually happens? They don't pay rent, right? So for whatever reason, the 20 ounces of silver is not deposited, right, on the 20th of May. In theory, Yale University can move to evict the church or whatever it is, right? So the answer I asked is kind of almost a trick question. Why would anyone bother doing a 999-year lease? Well, it's almost for show, right? You're effectively giving it to them in fee simple to keep in perpetuity, right? But here, you have some ongoing realization that you're special and that you're the boss and that you're getting this recognition every year. So I'm sure at Yale University or whatever it is, right? They said, we want to get this plan. We want to make people good about ourselves. They're very good at the Ivy League. If you ever go to an Ivy League, they're very good at brushing their shoulders, right? So if you go to the Ivy League, right, they're very good at this and they want to get this recognition. And they want to have this ostentatious ceremony where every year they drop 20 ounces of silver or whatever it is as a form of payment, okay? Yeah, go for it.
I was just, does tax implication come in at all for why they do 999 versus?
Oh man, so that's a good question actually. I think, hold on, I have in my notes, I don't think there's any tax being collected in the land because it's a church. And very often churches are exempt from property tax. I think that might actually be the case in Connecticut. I don't know.
So I was thinking less of property tax and more, if I gift it to you, then you have to pay the tax on gifts.
There was no gift tax in 1762. I mean, so had they gifted it in fee simple in the year 1762, there was no United States. The United States didn't exist yet. So, I mean, I don't know what the British tax law was there, right? But the interesting issue, though, is at this point, Yale will have to pay taxes on that 20 ounces of silver every year. So basically, in perpetuity, I don't know what does anyone know what 20 ounces of silver worth? I don't know. You can look it up, right? Whatever 20 ounces of silver is worth, that's actually income to the university, which would have to be paid tax on. Although Yale might have some tax-exempt status under the state. That's actually a controversial thing for Harvard. If I remember correctly, under the Massachusetts Constitution, they're actually tax-exempt as a university, so they get a lot of money without paying tax. I'm not sure about that. One slight note, the rule against perpetuities doesn't apply to these 999-year leases, right? Why? Because you're not giving a fee estate, right? You're not giving a fee estate. It's for a specific term of years, right? So there's no life and being you even have to measure. So this is perhaps one difference where it actually makes a difference whether you want to have it. Now imagine a different scenario. Say it wasn't just a 999-year lease. Say you gave someone a 999-year lease, but if for whatever reason they no longer use as a church, but reverts back to Yale, right? Imagine a situation like that. So if I were to write a rule saying, I give this to the church so long as that's used as a, so long as it's used at church, the organs perpetuities actually apply to that. So at some point, if we don't have a life and being to measure with, this would be void under wrap. But when you do as a lease and say, oh, no, I'm not giving to him, I'm just leasing to him with this condition, you can actually avoid the rule against perpetuities. Okay. All right, so that one's straightforward enough. Any questions on the fixed year lease? Okay, so just be careful if you ever see questions like, from A to B for 3 years versus from A to B for a lease of 3 years, right? Those are different things, and make sure you look for the lease because the law is somewhat different. Okay, Amanda, tell me, what is the next type of estate, which is called a periodic tenancy? What's the characteristic of that?
It's for a fixed period of time, like month to month, and the difference between this and the previous one is that you have to give notice of termination.
Excellent, very good. Okay, so the big difference between the periodic tenancy and the term of years is this is something that can repeat, right? With the term of years, it's going to end on November 5th, 2015, no matter what. There's no ifs, ands, or buts about it. Okay? But with the periodic tenancy, it repeats. And you know it's going to be a periodic tenancy because of the words. It's going to say something like from month to month or from year to year. And many of you have actually had this phrase month to month. Has anyone ever had a lease, say, for a year, and then you got over it and you hung around month by month? Has anyone ever done that? Yeah, we all have. Effectively, what happens, right? You signed a lease with your landlord for usually it's 1 year, right? That's a term of years. After the expiration of that year, your lease is over. And in theory, your landlord could evict you. But usually they don't want to do that. It's expensive. They like your rent. They like you as a tenant. So they convert you to a periodic tenancy, which is as a month to month. So effectively, each month, your lease renews. Now, has anyone ever had a problem with a month to month where they got kicked out or they stayed too long? Wow, you're all such good tenants. Well, it occasionally happens that perhaps the tenant wants to stay month for month indefinitely. And the landlord doesn't. The landlord wants to be able to rent it out to someone else for perhaps more money. So one of the key provisions of this periodic tenancy is you can kick the person out with notice. Okay, and the notice provisions are actually a little bit tricky is the wrong word, but it requires some math, which I know law students do not care for. Let's try a little math, right? Okay. So the common law rule, right? The common law rule, which is not really in effect in any state, but let's start off with the common law rule, is that you need to give half of period of notice. Okay? So the example is you have a 1 year lease, right? You need to give 6 months notice to vacate. Or 6 months notice to evict, right? It can work for either. So if you have a, now I'll actually just make this precise, a 1 year lease, so it's basically from year to year. I write that so you don't think that it's a term of years, it's not. So I'm saying you have a 1 year lease, it's a year to year lease, right? In order to vacate, you need to provide 6 months of notice, right? So the example they gave in the book is like this. So the lease begins January 1st, 2010, right? Right, so Chad, let's walk through this. If you have a year-to-year lease and it begins on January 1st, 2010, when's it scheduled to end? Yeah, exactly. 12/31/2010, right? It's basically 1 year. And if you want to leave the apartment on December 31st, on what date do you need to give notice? Which would be, exactly, yeah. So basically, you need to give notice before July 1st, 2010. We're going to do that. You need to give half the period. So with a year-to-year lease, you're required to give 6 month notice under the common law. So basically, you have to give before July 1st. And Chad, just finish it up. What happens if you give notice on, say, July 2nd? What what happens then? If you give notice on July 2nd, you miss a day.
Would it go just end of the lease ends at December 31st?
Of what year?
Oh, isn't that the, yeah.
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 So when does the lease end now? Exactly. At that point, the lease ends December 31st, 2011. Everyone see that? Because you didn't give 6-month notice, you effectively kick on another term, which is 1 year. Right? The common law rule is very strict. You had to give notice by a certain date. If you didn't, you were then liable for an additional year of rent. Questions on that? Okay. All right, let's try a different example. This is again under the common law, right? So you have a month-to-month, right? A month-to-month tenancy. It begins on January 1st, 2010, right? Let's go to Justin, okay? So your lease begins January 1st, 2010, and it's a month-to-month periodic lease, right? You give notice on July 20th, right? When does the lease end? I'm sorry, that's July, I meant March. You give notice on March 20th. When does the lease end? What date? Okay, not April 20th, but the end of the month. Exactly, 30 days, yeah, April 30th, right? Here's the rub. You need to have a full period, which is a month. You need to have one full term afterwards. So if you terminate on March 20th, your lease doesn't end at the end of March. You need to have one full month, which happens to be the entire month of April, and your lease ends on April 30th. Okay? Okay. In most states, I think this is basically all, this is more or less the rule you have to follow. In virtually every state, you need to give at least 30 days full notice, right? You need to give at least 1 month full. Even if you notify in the middle of March, you need to have at least one full month notice, which then kicks you to the end of April. Some states actually have a rule, which is very annoying, that you can't, if you start a lease on the 2nd of the month, you need to add one additional month. So say I moved in on January 1st, 2010, right? The lease would then end December 31st, 2010. But say it moves in January 2nd. In some states, they actually kick it that your lease ends at the end of January. They add an additional month. And that's really annoying. And you might see that from time to time. I had that in Virginia once. That was not expecting that. I was able to work around it. But they basically want to pick, I was living in Virginia for the summer for an internship. And I signed my lease, I think, June 2nd instead of June 1st. They wanted to add an additional month to my rent. I was like, I'd be back at school. That makes no sense. So be very careful. Some places actually do that. I don't think it's required by state law, but I think a lot of landlords pretend it is. Just they can milk another month out of you. It's annoying, and I'm glad I caught that because then I'd be on the hook for a month rent. Okay. Any questions so far? All right, Ravi, take a look at the question on page 444, please. This is problem number 1. I got it up here. And just read the first 3 sentences.
October 1st, L lease White Baker T for 1 year, beginning October 1st.
Okay, stop right there. I'm sorry. I always say read 3 sentences. I say stop. It says L leases White Acres T for 1 year, beginning October 1st. Robbie, what kind of lease is this?
For 1 year would be
Good. Term of years. Okay. Now keep reading.
following September 30th, T moved out without giving L any notice.
Okay. Keep reading. Yeah.
What are L's rights?
Okay, Ravi. So you said correctly that this is a term of years. Under a term of years, is there any requirement to give notice? When does a lease end on a term of years? At the exact date. It even says this, right? To a term of 1 year, beginning October 1st. So, Ravi, when will that lease end?
So the lease began in September 30th. It began 1 year from now.
Well, it begins October 1st, right?
Oh.
So when does it end?
A year from now.
Exactly. Right. So it ends exactly 1 year from the day you sign it. which is October 1st of the next year. So Robbie, if he moves out September 30th, is there any problem? Yeah, he's fine, right? There's no requirement to give notice for the term of years. All right. Summer, can you read the next sentence, please? Where it says, what if the lease had been?
What if the lease had been to T from year to year, depending on the
Okay, stop right there. If it said from T, start to T from year to year, beginning October 1st, what is the nature of this lease?
That's periodic.
Very good. It's a periodic. With a periodic lease, do you have to give notice before you vacate?
Yes.
Okay, good. So under the common law, right? Under the common law, you said it's 6 months. When would notice have to be given under the common law?
6 months from October 1st.
Do the math. I know you hate math, right? 10, 5. Yeah. Wait, hold on. I never do the math in my head. Yes. So 6 months. So September is 9. Yes. So March 30th, basically. So you need to give a notice before March 30th, right? Are there 30 days in March? Yes. 30 days September. 31. I never remember that 30 days has September. Whatever. Yes. March. Yeah.
Would it be, you have to give notice before April 1st or March 3rd?
You need to give it before April 1st. Yeah. If you want to be really precise, you need to give it before the month. So basically, the 1st of April is considered the month, right? So what makes 6 months actually somewhat inaccurate is that not all the months have equal number of days. So it's not 6 times 30 or 6 times 31. You have February in there, you have 30, you have, if you have a leap year. So basically, you have to give notice before April 1st. Okay? Now, Rhiannon, what would happen under the modern approach? How much notice would have to be given to vacate by October 1st?
A month?
Right, when would that be? So if you wanted to leave October 1st, when do you have to give notice by?
Oh, you have to specify September 1st.
Before that,
Before that.
what would that be? If you want to leave October 1st, you need to give 1 full month.
August 31st.
Exactly. If you want to leave under the modern law, you need to give 30 days full notice, right? So if you want to leave October 1st, you need to give the entire month of September's notice, which would basically give notice by August 31st. And if for whatever reason you dallied and you give notice till September 1st, you're now on the hook for another month. And when you're on the hook for another month, that means you're liable for the rents, right? You have to pay the rent in that period. We'll do cases next class or the class after about mitigating damages, where if the landlord rents it to someone else, you don't have to pay it again. But this is a problem. So, is it hand?
Yeah.
Okay. All right. Ashley, can you read the last sentence? Is what if the lease had been this one, right?
What if the lease had been for no fixed term at an annual rental of $24,000 people, $2,000 per month?
All right. What do you think? How do you think you'd characterize this lease? Because we're starting to see it doesn't necessarily neatly fit into the two and almost 3 categories we have. And what exacerbates this topic is very often leases are written by non-lawyers who don't really know what they're doing. And they think they heard this one's like, oh yeah, month to month. I'll just throw that word in there. Oh yeah, it's a term of lease. Like they'll know certain words and they'll handwrite in. That's the Gerrish case in a couple minutes. So courts often have to grapple with these questions that don't fit in neatly. Ashley, how would you handle this one? What would you call this? Good. Yes. And see, that's the conflict, right? On the one hand, it says annual, which you think means year to year, right? But then you see something that says $2,000 per month on the first of each month, which makes you think of month to month. This could probably go over away. Most places probably consider this a periodic tenancy as a month to month. And the reason why is because it specifically says payable $2,000 per month on the first of each month. And in situations like this, courts will probably defer as a month to month. In general, courts don't like year-to-year leases because they're so long, right? They require giving so much notice in advance before you terminate. A month to month, you need to give 1 month notice, and that's more acceptable. Any questions on that one? All right, you want to take a look, Troy, at question number 2, please?
He subsequently vacated on that date and paid no further rent to L.
Mm-hmm.
L, after reasonable efforts, finally re-let the premises beginning April 1st.
Okay, stop right there, okay? So you're in a month-to-month, right? On November 16th, you say, I want to vacate November 30th. Is that sufficient to vacate November 30th? If you give notice on November 16th, what is the effective end of the lease date? When does the lease effectively end if you give notice on the 16th of November? 31st. Yeah, yeah. The little things, right? You have to put on your outline. 30 days, that's September, April, June. Okay, so 31 of December is when the lease ends, right? Everyone see that? So even though he said, oh yeah, I'm leaving November 30th, he didn't actually end the lease. So then Troy, is he on the hook for the month of December rent? That's right. He's on the hook for the December rent, even though he pretended to give notice wasn't sufficient. Okay? But now it turns out that the apartment wasn't rented out till April. So you have January, February, March. You have these 3 other months rent. Troy, is he on the hook for those 3 months? That's right. How come? Well, think about it. When did the lease end? You said it a minute ago. Are you on the hook for rent after your lease finishes? No. That's right. So you're only on the hook for when your lease is active. Once your lease concludes, you're not on the hook anymore. All right, so the question here is he's not liable for the rents. He's liable for December rent, but he's not liable for January, February, March rent. Everyone see that? Questions on that?
I'm just wondering why we're talking to the end of the month. And then what if I'm moving to a place on the 7th? Is it, why are we saying until, what if he moved in on the 7th?
Okay.
Of this month? It always has to be like a month plus
Yes.
that?
Right. So basically, this is why the apartment I moved into, they tried to scam me, right? They tried to say, oh, no, we want to make it really easy. So that way all leases begin at the beginning of the month. But you're absolutely right. Some people move in the middle of the month or whatever. Even if you move in the middle of the month, it still carries over to the end of the month. It doesn't matter, right? So even if, say, he had moved in on November 16, 2011, right, a year before, he would still need to give a full month notice to go beyond it, right?
But a full month would leave him at, like a month, we're saying just in the word September.
No,
not
you
in numbers.
need an entire calendar month. Yes. It's not just 30 days, period. You need a full calendar month. So you need a full month of December. That makes sense, right? And again, months are in different lengths. Some are 28, 29, 30, 31, whatever, right? But you need a full calendar month. So the poor guy who gets screwed on leap year, it's like, I missed the 29th of February.
So if he wanted his agreement to end on November, he should have given the notice in October.
Exactly. If he wanted his lease to end November 30th, he would have had to give his notice by Halloween, right? October 31st. If he gave his notice on Halloween, he'd be good to move at the end of November. So usually it's a smart move to give your notice on the last day of the month, because if you give it October 31st, you can then move at the conclusion next month. Because that way you have the entire month of November is clean and you're out. You get that, Maria? Okay, good. All right, questions on that? All right. So the next one is what's often called the tenancy at will. Has anyone ever had a relationship like this, a tenancy at will? So these are very risky, right? Because you don't really have much protection. Meredith, tell me, what is this tenancy at will?
It basically goes on as long as the landlord and tenant want it to. There's no fixed period of time.
Okay, very good. The tenancy at will is basically enduring at the will of the landlord and the tenant. And it goes on so long as both of them want it. Okay? Most of the time, in virtually every single state, you need at least 30 days notice to terminate the lease when you're at will. Okay? But historically, at common law, both landlord and tenant had the option to cancel the will. Cancel the tenancy at will. Both landlord and tenant were able to cancel it or terminate the lease. This puts a tenant in a very shaky position because with 30 days notice, he or she can be kicked out. Okay. Now you might be asking, what's the difference between a periodic tenancy and a tenancy at will? There isn't much of a difference in practice. In both cases, the landlord or the tenant can terminate. The only slight difference is the notice periods. Because with the periodic tenancy, you need to give basically the full month notice, right? With a tenancy at will, you need to give 30 days notice. And those aren't the same thing. This was basically Maria's question a minute ago, right? If you give notice on Halloween to move out at the end of November, that's 30 days. But if I give notice on October 2nd, it's basically 30 days plus 20 something. So there's slight differences, okay? But the main difference, again, is that both parties, historically at least, had the power to terminate. But as we'll see in the first case, actually the only case, I guess, courts have started to read the tenancy at will very liberally in a way to give more protections to the landlord. Okay, any questions before we get started on the case? All right, Adriana, what was the problem in the Gerrish case? What was the issue there?
Well, Jonathan leased land to Gerrish, and he leased it for a fixed amount at $100.
Mhm.
There was no definite time period on there.
Good.
On the lease, it just said, I guess, like as long as you kept paying the rent,
Right.
you could stay there. Then Jonathan dies, and his executor, Garner, wants Gerrish to leave the property.
Very good. All right, let me see if I can find the language. Okay, so this is the language. Can everyone read this? Is it big enough? Okay. So we have the situation. We have these two guys. The tenant's name is Lou. And he comes to sign a lease. But as is often the case, when you're dealing with non-lawyers who aren't, professionals, they mess it up. There's no way of saying it. They took a standard form, they added some stuff in with a typewriter, they added some stuff in by hand, and if you remember back, Mr. Robinson, oh no, you didn't see the video. Sorry, wrong class. But if you remember back, people often always try and write stuff in by hand, okay? Now, in a few minutes, we'll discuss form leases, right? And why virtually every single lease you sign is the same. And you may say, oh, it's not fair that I can't negotiate with my landlord to try and get more favorable terms of your lease. If you had non-lawyers writing in terms of a lease, this is what happens, right? So I know it may seem unfair that you're signing these form leases that you don't really understand, has all these language that's probably not favorable to you. But in many respects, that's much better than doing this, which creates an absolute mess and it doesn't know what the heck the court's to make of it, okay? So here's what the lease says, right? The blanks are filled in. They describe the property. Rent is $100 a month. And by the way, that's fixed. That can never be changed. So basically, as long as he's alive, you can inherit a leasehold state. There's no future remainder, right? As long as he's alive, the rent is $100 a month. So if he lives to be 120, that's a really cheap rent. And it says, with respect to the duration of the tenancy, the lease provides for and during the term of quiet enjoyment from the first day of May 1977, which term will end, dash, Lou Gerrish, not Lou Gehrig, not related, Lou Gerrish has the privilege of termination, this agreement at a date of his own choice. And what you should know is anything in italics here, the emphasis added, was written in either by hand or typewriter. So that's where that's where they messed up. So let's look at this very carefully, right? It says for and during a term of, okay, so this was a blank, right? What do you think the person who drafted this form book wanted to put in that blank, Samantha, for a term of, what do you think they thought to put in there? Yes. So probably they meant to put in a term of 1 year, 2 years, month to month, right? The fact that this is term of blank means they wanted to put in one of the known forms of leases which we've studied. But instead, for reasons I don't know and no one really knows, they wrote quiet enjoyment. Did we discuss the word quiet enjoyment? Do you know what that means? It's not really shh. Yeah.
Doesn't it pertain to nuisance, like,
No,
Yeah.
that's what everyone thinks it means, like, shh, quiet. No. Quiet enjoyment means no one else will claim superior title to you. So this is like what happens if, I sell Blackacre to Alex, and I sell the same Blackacre to Carson, right? And the car says, hey, I own it, and they start suing each other, right? At that point, Alex will come back to me and sue me because basically someone else was bothering her and her title. This is an entirely inappropriate word to put there. It makes no sense whatsoever. But again, they're not lawyers, so they probably meant to write a term of year or month to month or whatever else, okay? So pretend it says foreign during the term of, 1 year from the first day of May, which term will end blank. What do you think they meant to put in the second blank, Jacqueline? This is not just a dash. This is actually a blank in the form. What do you think they meant to put there?
The exact date.
Yes. Yes. So imagine it said, right, foreign during the term of 1 year from the first day of May until the end of April 1977, right? That's what they should have put. But again, they put instead this. They wrote this in by hand. It says, Lou Gerrish has the privilege of terminating this agreement at a date of his own choice, right? Ashley, what's the significance of this handwritten notation? What does that mean?
I mean, that it's up to him. I mean, I think that's the significance that he gets to choose. when he
Good.
leaves.
So it seems clear, right, from the intent of the parties that they did not choose a term of years. They did not choose a periodic tenancy. They didn't say to end on a certain date. Instead, they scribbled in that Lou has this privilege of terminating it at the date of his choice, which basically means whenever he wants to terminate it. Okay, everyone get what the form book was aiming at and screwed up. So this is why, and it's kind of an ancillary legal topic. Have any of you ever used LegalZoom or any service like that? I've used it. So there are great pluses and minuses to tools like LegalZoom, right? So the massive plus is that they bring legal services at a low cost to people who need it and might not otherwise pay for it. There's a serious shortage of legal services in this country, and there's definitely a gap of people who need property disputes or wills, whatever, drafted. The downside is that you don't have lawyers reviewing them, right? And when you have people like Lou Gerrish writing this in, it often creates more headaches than it's worth. So as counterintuitive as it may be, it's sometimes better to have no legal document than a bad one. Trust me on this one. It's sometimes better to have no will than to have a bad will, because the lease estate and testament statutes will actually protect you somewhat and provide probate. If you have a bad will that gets messed up, it might actually put your family in a worse state than otherwise. Now, again, I'm not knocking services like LegalZoom. I think they provide a very valuable service, but there's a serious risk of shortchanging something like the law, because generally speaking, you don't realize there's a problem until something goes horribly wrong. In the case of will, when you're dead, right? You don't know that something's wrong until you die, and then finds out that perhaps you didn't get the right signatures, or perhaps the thing wasn't attested properly. It's like, oh, whoop, you have no will. So sometimes, again, people taking the law into their own hands, not always a good idea, because they start making up new forms of leases. All right? So, okay, so as it turns out, so Gerrish is living there a number of years, and then Donovan dies. And then someone else moves in and says, hey, I'm giving you notice to quit. Scram. Get out. All right, Allison, is there anything in this lease which gives to the landlord the ability to terminate it?
No.
Okay, good. The lease is entirely silent about the landlord's ability to terminate. So again, if they hadn't written this in, right, had they made a year to year or month to month, under the law, it's presumed that the landlord has the power to terminate. If it's a tenancy at will, it's presumed the landlord has the power to terminate. But because they scribbled this in, they basically created some sort of fictional leasehold where the landlord has no power to terminate. So as it's written out, if you read just the text, right, Gerrish is in here for life, and he cannot be thrown out so long as he pays the rent, presumably. And even then, it's not clear. But presumably, as long as he pays the rent, he can stay. All right, Brian. So how do the courts approach this? How does a court look at this will? The Court of Appeals, the highest court in New York. Everyone know, by the way, in New York, the highest court is not the New York Supreme Court; it's the New York Court of Appeals. Now, in fact, the Supreme Court is the trial court because they have supreme jurisdiction over everything. It's a court of general jurisdiction. Maryland has the same regime. This is why in Law and Order it always says Supreme Court. It's the trial court. It's called the appellate division, which is so so unpersuasive, right? So basically, it's called the New York Supreme Court, and then the appellate division, part whatever, right? And then the New York Court of Appeals is the highest court.
Is it Maryland?
Maryland has this. No, I'm talking about New York. In Maryland also, it's called the Maryland Court of Appeals is the highest court.
Oh, okay.
I think in Maryland, though, the trial courts are called the district courts. I might be wrong about that.
Thank you so much for telling me why it's Supreme Court.
See?
Because I've
Yeah, because
never-
they have supreme general jurisdiction over everything. In fact, remember we did Pearson v. Post, right? There's actually an error in your book, which I didn't bother mentioning because it was the first day of class. It's called the New York Supreme Court, right? That's what the book, go to the first page of your textbook. It's called the New York Supreme Court. It was actually called the New York Supreme Court of Judicature. I don't know why they called it the New York Supreme Court. That's just an error. I'll go write notes to the editors. But it's called the New York Supreme Court of Judicature because they actually reference in the opinion the Supreme Court, which is the court in Queens, which was the trial court. So actually the opinion is not even consistent with itself, but I'll let that go for now. All right, Brian, so what did the court do here?
So the appellate court was kind of looking at whether it was kind of this, I guess they were kind of focusing on whether they should go with the intent of the party or if they should kind of dial back to more.
Well, okay, good.
More
So
common law approach. So they start out with like addressing the common law.
good. So first of all, Brian, and I think you're about to hit on this. Under the common law, was it presumed that if one party had the right of termination, the other party had it as well?
Yes.
That's right. Okay, so under the common law, right? This was Lord Coke, whose visage I burdened you with here. He was a very famous judge. He was involved in the powder keg plot, among others. But Lord Coke had this famous expression saying that in any leasehold where the tenant has the right to terminate, so does the landlord. And I guess that makes some sense, right? Is it fair that if the tenant can terminate, the landlord may go forever? But the modern courts haven't been so keen to that ruling, Eric. What have the modern courts said? When you have a lease that gives the tenant the right to terminate, but not the landlord, how should courts understand that?
It should be interpreted according to its plain meaning. And
Good.
take more of a general contracts approach rather than common law.
Yes, perfect answer, okay? The modern courts, and you'll study this in property as we move from this semester to the next, but in the 20th century, the modern courts have started to incorporate contract doctrine. I think I maybe told you in the first day of class that for common law property and contract are very different. And you've seen this, right? There's a lot of things that are just damn unfair. But contract law is often concerned with fairness, with equity, with finding the intent of the parties, etc. So courts have started to incorporate contract doctrine into property doctrine. But they can't do it with fee estates because that law is like 800 years old, right? They're not going to change fee simple. They're not going to change future interest. And as a result, we have this balkanized, complicated system of law. But they can change it with leases, right? So here's a dirty little secret, right? Leases are treated not as fee estates, so they're more open to importing other things. There's been massive landlord-tenant law passed by statute. There's been massive changes in leasehold law by courts where they bring in contract doctrine. So Eric was exactly right. They brought in this doctrine saying, let's look at the intent of the parties, right? Let's get rid of this common law presumption that both parties have the intent to terminate. If we look at this language, it's really clear that the only person with the power to terminate is Lou, the tenant, right? The landlord has no power to terminate. Questions on that? You'll see this more and more and more and more, where you see various contract doctrines being incorporated into property. When we do landlord-tenant law in the next couple of classes, this hits very strong. Okay? All right, so questions on this so far? All right. So then they go into this entire discussion of Livrier-Sizen, right? And I remember Livrier-Sizen with the twiggle, right? Remember the clod of dirt, right? Whenever a court starts talking about Livrier-Sizen, they're about to reverse a common law rule. That's a good indication. I think we have maybe one other case like that this year. If they mention Livrier-Sizen, they're about to reverse a common law rule and do something modern and fair. And I mean, it does make some sense, right? Why shouldn't the party's intent be fulfilled, right? This is very clear. The plain text says Lou has the power to terminate, not the landlord. Okay? But Christian, what's one of the problems of the court ruling in favor of Lou in this case?
I assume it creates some precedence towards, you know, I don't know.
Well, okay, so we've discussed 3 different estates, right? There's the term of years, there's the periodic, and there's a tenancy at will. So right, we've named 3. Which one is this?
Tenancy.
What do they call it? They had a very specific name. Elise, you have it? What do they call this one?
I just know that they reverse the judgment when it's determined what tenancy, but that's not.
No, but you're right. Okay. What's murky? No, you're actually right. What's murky here is that there are only 3 different estates, right? There's the term of years, periodic, and the at will. And there's something called the numerus clausus, which I don't know if you've ever seen this phrase before. It's a little Latin for you. Mention the notes. What this basically means is that there are a certain number of property doctrines, and there are no more, right? So this we have, fee simple determinable, life estate, like there are a fixed number of them. But here, the court basically made one up, right? And it's not even clear exactly what they called it. Perhaps it's called a lease for life, right? Or maybe a life estate determinable, or I'm sorry, a tenancy at will determinable. Can't spell. It's actually not entirely clear what they call this. And if you notice, the court fudges a little bit, right? They begin by saying, here are the different types of estates. And, this doesn't really fit into door number 1. It doesn't really fit into door number 2. It doesn't really fit into door number 3. So let's make a 4th door. There's nothing inherently wrong with courts making up new things, but it doesn't really make sense, right? If you want to give someone a lease for life, Catherine, what do you give them? What would you actually do if you wanted to actually be a lease for life and to fit within our property system? What would you call that? A life estate, yes. My God, of course, that's the easiest way of doing this, right? If this is for Gerrish's natural life and it can't be terminated, give the guy a life estate. Now, the one drawback to that is there can't be rents. You remember, we can't have rents for real property. Those are very rare, right? So that perhaps is one reason why. Or you could do a periodic tenancy, right? You could say Lou Gerrish has it from year to year, terminating upon his death. So effectively, at that point, you have a periodic tenancy that ends on his death. And you can make clear that only he has the right to terminate. But here, they effectively did something weird. They gave him effectively a life estate where he's paying rent. I mean, that's more or less what this is. And some of the notes after this case are very critical of it because they're saying, listen, they're just making stuff up, right? You have these non-lawyers who, screwed up the form. They didn't really know what the heck they were doing. And now court comes and bails them out by making up this estate. And oh, by the way, now we get rid of the landlord's right to terminate. Right? They just carve that out of the law with a very, very messy will. All right. Yeah?
Oh yeah, so could you have done it also as you said periodic, but could you also have done like a term of years, which is the term of your life?
No. The reason why is the term of years has to end on a specific date, and no one knows when they're going to die. I mean, I suppose you could have said for a term of 100 years, and no doubt he will die before then, in which case, it goes back to the landlord. Right? You could say for a term of 150 years, which is longer than any person lives, right? And that will have accomplished that. Because it will definitely end on, was it 2065, whatever the year is.
But it'll end before that because you die.
Well, if you end, the lease terminates.
Right. So, and that's another question about the 999-year leases. I mean, is it because it's not to
it's to a corporation.
But if that corporation dies, then the lease dies too.
But the beauty of a corporation, and why the reason we have corporate law is it goes beyond the life of a person. Right? Corporations like a church chartered in Connecticut is still in existence in the same charter.
Yeah, but what if like it goes out of business or
Then it goes back. Goes back to Yale.
So that is.
Right, right. I mean, so I guess maybe one example. Say it was a Presbyterian church and they sell it to a Catholic church, right? Can they keep it? If the lease is to one specific church, can they transfer to another church? And that actually was a sticky issue. Because in fact, a lot of the Episcopalian churches, which I think is what it was, have actually split from the English national. They're called Anglican. So this actually came up a lot in Virginia. A couple of years ago, the Episcopalian Church started to ordain gay bishops. And a lot of the churches in America didn't like that very much. So they actually fractured off. So they became what called churches. And there were a lot of leases giving the land to hold to the Episcopalian Church. They were no longer Episcopalian, they were Anglican, and they lost some property. And the church in Virginia, I can't remember how it turned out, but this was going on for litigation for years. And I think in the end, they actually lost the land because the lease was probably 400, 300 years old, was to the Episcopalian Church. Well, some guys will, right? So this does come up a lot. Other questions?
This is, I forgot to ask this right before we do the case, but we've been talking about when leases start on January 1st or whatever, but a lot of them start on January 15th. So when you said that the periodic tenancies, or you said that has to be a full month
Of notice, yes.
30. So would it be, that still remains?
Yeah, it's the same. So say if your lease begins January 15th, right? Your lease is scheduled to then end on January 30th.
Well, no, I'm saying about a month like.
You still need a full month no matter when your lease starts, a full calendar month. So the entire month of February needs to be blocked
So
off.
it's month to month,
Yeah, you need a full calendar month.
so till February 30th.
Well, 28th, but yes, exactly. Right.
Okay.
All right, let's take a look at the questions after the case. Problem number 2, I think it's page 448, I think. You want to take a look at that, Jason? Question number 2.
L leases Orange Acre to T for as many years as L desires. What estate does T have?
By the way, I had a Jersey Shore question a couple years ago, and it was Orange Acre was one of the fees. So I see they're on a similar mindset. What do you think, Jason?